You were, Ms. Carter, ma'am, you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I see that she's also on bond for an aggravated assault with a deadly weapon as well, huh?
That's correct, John.
Okay.
Officers were dispatched to an assault in progress, stating that approximately 50 people were fighting. Upon arrival, officers observed a large crowd and another law enforcement trying to detain individuals. Law enforcement began to conduct the crowd control, giving clear verbal command for everyone to back up and disperse. Individuals began to walk away, but the defendant did not. Law enforcement told the defendant to get back, but she refused and got into their faces. Law enforcement then pushed the defendant back and she came right back up and pushed him in the chest with both hands. The defendant then threw an unknown object at law enforcement, which struck him in the face and chest.
What?
Law enforcement then attempted to place the defendant under arrest for assault of a peace officer, but she actively resisted by pulling her hands and arms away from them. Law enforcement then took the defendant to the ground and she continued to resist by not allowing them to control her arms, pulling them away.
Do we know if a felony charge is on the horizon?
I would have to double check, Judge, speak to the officers to see what is the result of the assault on a police officer.
What time of day or night was this?
This was around 22:41, so 10:41. Yeah.
Ma'am, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're ordered not to have any contact with the complaining witness in this case. Where was this location?
This was located at 9601 West Montgomery Road. And let me see if it's a business.
You were not allowed to go back, and I'm now going to give you a curfew of 7 p.m. to 7 a.m. I do not want you out at night at all. Do you understand? I'm going to protect my community at all costs, and you're very lucky you're not charged with a felony assault of a peace officer. Stop. You are already on bond for an aggravated assault. You've now picked up nearly 2 new cases. If you endanger my community, I'm going to make your bond so high you will have patches of hair falling out. Do you understand, Ms. Carter? No going out at night, no contact with any of the co-defendants in this case, no dope, illegal drugs, alcohol, random testing like crazy. Do you understand? What do you do for a living?
I was a CPS case worker as well as working in mental health.
Are you still employed at this time?
I have a podcast. I was an ex-athlete, so I have a podcast.
I'm just concerned whether you have an income or not, whether you can afford a lawyer or not.
Not currently.
You work full time.
I do not. I have a
You said you're a CPS caseworker. You've got a podcast. You do something else. How do you support yourself now, Ms. Carter?
My family, my parents.
When is the last time that you've had a full-time job? A tax-paying, full-time 9 to 5 job?
I haven't. I worked at it.
When is the last time you've had what year?
This year. I worked as a chef at Coffee.
It is time for you to get a full-time job.
Yes.
When people have too much time on their hands, they become self-destructive, and I'm now making that a condition as well. I can have you apply for a court-appointed lawyer, but I'm bringing you back in 2 weeks, and I want to see what you have done to get a job. If you fail at anything, I'm telling you now, I will put you in custody. I have no problems. Your bond is $5,000 on the felony. I have no problems making it 4 to 5 to 6 zeros after the fact. Stop. I want you to understand what the expectation is. You're on bond for a felony. You've picked up a new case. Do you understand? We will not. This is the only warning that you're going to get. For now, I'm going to have you sign a reset. Deputy will give you an application for a court-appointed lawyer. I'm going to have you meet with Veronica for your bond conditions, and then we'll have you take a seat over there in the pew.
Bottom of 3, Edwards, come on up.
Do you have an arraignment?
I have 2, Your Honor.
Okay. We'll do it next.
Thank you, Your Honor.
Yeah, for sure.
Michael, can I tell us about everything?
You said,
Bottom of,
I heard 9. But I didn't get the
oh, Edward, bottom of 3.
Edwards. All right, good morning, Miss Edwards. Ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Officers were dispatched to a location, a residence in Harris County, Texas, in reference to a theft. Upon arrival, law enforcement met with the defendant, who stated that she let the complainant borrow her shoes, but the complainant told her that she doesn't have them anymore. Law enforcement gave defendant the case number for the theft and advised her to leave the location and make no further attempts to contact the complainant. Approximately 30 minutes later, law enforcement was dispatched to the same location. The reporting party was the complainant's mother, who stated that 3 Black females, one of them being the defendant, were outside her residence trying to fight her. Upon arrival, law enforcement made contact with the complainant and her mother. The mother indicated that she told the 3 females to leave, but they were refusing to do so. The complainant was observing this through the window. Once outside, as she was worried about her mother, the complainant stated the defendant then walked towards her, stopped at the street corner, and maced her. Law enforcement viewed the ring camera showing and confirming the complainant's story.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons and not to have any contact with this complaining witness and not to go where they live or work. If you violate these conditions, I will revoke your bond and put you in jail. There will be no more PR bonds for you. Do you understand, ma'am? How old are you?
18.
What do you do for a living? Nothing.
I don't want.
Why?
I was graduated.
What?
I was graduated. I stopped college 16 months.
Great. Are you actually enrolled in college?
Huh?
You actually enrolled. You're going to start.
Yes.
Okay. How do you think this helps? You know, employers look at a multitude of things when they're hiring people. They look at records, they look at criminal history, they look at grades, and the more stuff you pick up, you think it gets better, you get worse. Miss Edwards, does it get better or does it get worse the more criminal cases you pick up? Keep that in mind, ma'am. We can have you fill out in a court for a court-appointed lawyer. We will have bond conditions created for you to sign. Do not endanger my community. Do you understand, ma'am? Hello?
Yes.
Yes, sir.
I mean, should we just reset the case? I mean,
Judge, she did send an email requesting to reach the hiring attorney. And when I tried calling her, she was on that.
Oh, because I was already in here.
okay, we'll do THA then.
Okay.
Okay, all right. Please, just do not leave until you sign the bond conditions, ma'am.
All right,
Good morning,
Judge, now
Ron. How are
this
you?
is approaching
Hi, Mr.
for 14 and 15, Segovia and Signal. Co-defendants.
Yes,
Ms. Edwards, write this way.
so there are actually 2 different offense reports written by 2 different officers. So we could start.
Are you here on the motion to sub?
Is that, and he's got to be the RM, he's on docket today.
Got it, okay.
All right, I'm getting both signed.
Michael, you,
Segovia first and then second. If we could do Mr. Segovia first, there are actually 2 different offense reports written by 2 different officers.
2 different transactions?
Same transaction. And the information is the same, but it's written by 2 different. One officer, it's basically a long game of telephone on each one.
Oh, Lord.
So this one is the longer of the telephone conversations.
All right, gentlemen, both of you are charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. Both of you speak English?
Yeah.
We are going to do probable cause. You have the right. That's Segovia.
This is Mr. Segovia.
Got it. All right. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
The officers were driving an unmarked sheriff's office vehicle in Harris County, Texas, when they observed a white F-150 and a black Mustang driving side by side. The vehicle simultaneously slowed down to 45 miles per hour in a 65 miles per hour zone, and then both accelerated to speeds of up to 120 miles per hour. Law enforcement were able to capture footage of this on their department-issued phones. Law enforcement advised Mark Judas of the incident, and they were able to conduct a traffic stop on both of the vehicles, which were both in these defendants, Judge.
Who's in the truck?
That's what I'm trying to.
Mr. Sino was allegedly in the truck and Mr. Segovia was allegedly in the truck.
In the what?
In the
Mustang.
Mustang, in the black.
Okay.
Here's the important thing on both. So both have very similar information. They both have, essentially the same set of facts.
Okay.
And the observations of the witnessing officers are relayed in the same manner. They talk about how one client is in lane 1 and the other is in lane 2, and that they slow down 45 and a 65, and then they accelerate. What is missing from both of these reports is that they were ever lined up from a point side by side and accelerated from that point. So one lane 1, one in lane 2, and then they accelerate is not racing. And the speed is irrelevant to racing because there's no element of speed in this offense. So while they're both written by different officers, it relays the same information that there is a lacking element witnessed by the officer, which is that lined up point side by side.
So Judge, they indicated that they were participating in rolling drag racing. They indicated that the officers was able to report this into his phone, that it is correct for the Ford 150 was in lane 1, the Ford Mustang was in lane 2. They're both going together. Ford Mustang slowed their operation speed before accelerating at a high rate speed, participating in a rolling drag race. The other officers that conducted the other traffic stop did observe that video and also determined that they were both.
If they're saying it's a drag race, then the definition of a drag race is 2 or more vehicles from a point side by side at accelerating speeds in a competitive attempt to outdistance.
So I understand that. And I'm very happy that once again, the officers included the definition of a drag race. And then, next section, they write about their observations of what they saw. And they saw 2 vehicles, one in lane 1 and one in lane 2, slow down and accelerate. However, in that observation, the personal observation of the officer, not the definition of racing, they never say that either of the vehicles were lined up.
He said they're in a drag race.
Well, I understand, but that's defining the word with like you can't define the word with the word you're defining. So I'm glad that they know what the code says about racing, but when they talk about their observations, there's a disconnect between that because they don't mention that either of these gentlemen were lined up from a point side by side and accelerating from that point.
But drag race does say that.
The definition and the code says that.
I don't.
But
And Judge, if it makes the court feel better, looking at the PC statement, they do indicate that these vehicles were driving side by side, aligned, the vehicles aligned, a rolling drag race begins once the vehicle accelerates simultaneously side by side in an attempt to outdistance, outgain each other. They defined it in their offense report, but they indicated in their DIM summary that they were participating in rolling drag race, and that's what.
in the DIMS report, it just mentions that a drag race is this, and then they tell in their narrative what they observed, and in the observation point of their narrative, it never mentions that they were ever seen.
I don't agree. I think that it's sufficient, especially for the low burden of probable cause. Gentlemen, I'm going to find that there's probable cause to go forward with each of your cases. If I find that you participate in actions like this again, I will revoke your bond and put you in jail. Do each of you understand? Not only that, the district attorney's office has started seizing and taking cars from individuals who participate in multiple drag racing. There's a place to do it, not on 610, not on 59, not on I-10. Do you understand, each of you? Do they have licenses to drive?
They both have valid licenses.
All right, you must maintain liability insurance as well. We will have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. Because you have him as a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Stoll. If he tells me he cannot get a hold of you, I will revoke your bonds and put you in jail. Do not pick up any new cases. Do each of you understand? Okay, we'll have you sign a reset. I'm going to have you take a seat in the pew over there. Once you get the bond conditions, you sign it. At that point, you're free to go. All right? Please, gentlemen.
Judge, just to make sure the bond conditions were.
Just no racing, reckless driving. Yeah.
All right, Judge, top of 7, Melendez, come on up.
Yeah. Yeah, you got short, all right.
I have signal for.
That's Mr. Sigmund right here.
We'll do yours next.
That's fine, Judge. That's fine. Thank you. I appreciate it.
Yeah, for sure. What was your last name? All right, Mr. Melendez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, sir.
Okay?
On August 8th, 2026, an officer was dispatched to the intersection of Uqua Street and Sabo Road, which is a public roadway in Harris County, Texas, in reference to a traffic hazard. Upon arrival, the officer observed a silver Dodge Ram pickup truck remaining stationary in the middle of the roadway. The officer approached the vehicle and observed the driver, the defendant, to be asleep behind the wheel while the engine was still running. The officer banged on the window multiple times, but the defendant wouldn't wake up. The officer then instructed the tow truck driver, who was on scene, to unlock the door due to there being an apparent medical emergency. The tow truck driver then unlocked the door and placed the vehicle in park. The officer then began shaking and shouting at the defendant, and he eventually woke up. While speaking with the defendant, the officer detected a faint odor of alcohol emanating from his person. Field sobriety tests were then conducted with 6 out of 6 clues on the HGN, 3 out of 8 on the walking turn, and then 0 out of 4 on the one-legged stand. The DIC was read, but the defendant refused to provide a sample of breath/blood, and that blood warrant was signed and executed.
Does he have a license to drive? Please.
I'll pull it up, Judge. What is the last name? He can't.
Melendez.
Yes, he does, Judge. It's Mendoza.
Mr. Melendez, I'm going to find that there's probable cause to go forward with your case. You just had one dismissed. I'm now requiring you to obtain an ignition interlock for your car. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If I find that you do, then I will put you in jail. There will be no more PR bonds for you. Do you understand?
Yes.
You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If I find that you're using, then likewise, there will be no more PR bonds for you. We are going to reset your case to give you time to hire a lawyer.
I have a lawyer.
Who?
It's Steven Stewart. He said he's gonna be here in 30 minutes. I don't want to do that.
Okay, so let's, I don't see any paperwork. Do you?
I don't see that.
Okay, so what we'll do is we'll get everything ready. We'll have the reset done. We'll have your bond conditions done. And then when he comes, then we can, he can pick a date. Okay, please.
Judge, counsel has a video.
Yeah, it's okay. Yeah, let's, come on up.
Thanks, Judge. I appreciate it. I got a PS5. Derek Johnson.
Can you file the guardian interlock paperwork with Homeboy?
Yes, Judge, it's there.
Got it, okay. Derek Johnson, come up.
It's on Burnett. He picked up a felony. So.
That's no bueno. Come up, Mr. Johnson. What is the one thing we told you not to do? Pick up a new case. And now you've picked up a felony violation of a protective order. What happened in the case, please, in the felony one?
Yes, Judge. On July 30th, 2026, an officer was dispatched to a disturbance call. The officers arrived and observed the defendant and the complaining witness through an upstairs window. The defendant ran downstairs and attempted to run out of the back of the house. The officers approached. The complaining witness stated the defendant had hopped the fence. The officers detained the defendant from where he was hiding in a bush. The complaining witness stated she came home around 1 a.m. She was showering. The defendant came to the residence and accused her of being unfaithful. The defendant slapped the complaining witness, causing pain. The complaining witness called the report, but officers did not arrive until later. The defendant was already caught.
Okay, Mr. Johnson. I'm revoking your bond. You're going to jail today. And I'm going to tell you now, I'm going to put a GPS monitor prior to your release. If you get out, if you go anywhere near this house or person, I can have a hearing to hold you at 0 bond, and I will do it in a heartbeat to protect every person in my community. You're not to go within 1,000 feet of where she lives, works, or breathes. Do you understand? Okay, it goes with you. Set it at 5,001.
Thanks, Judge.
Okay,
Yeah.
and I signed your motion already.
Thanks, Judge.
All right, Judge, the next one is top of 8, Molina.
All right, good morning, Ms. Molina. Ma'am, you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, sir.
Okay.
On August 8th, 2026, an officer was dispatched at 3401 Garrett Street, which is a public roadway in Harris County, Texas, in reference to a crash made. Upon arrival, the officer made contact with the defendant. While speaking with the defendant, the officer observed her to have glossy eyes and there was an odor of alcohol emanating from her breath. The officer also observed a 1.5 liter buzzball laying on the ground. The officer detained the defendant and then spoke with the occupant of the other vehicle, who hereinafter is the witness. The witness said the defendant hit her vehicle and she had a baby inside the vehicle and failed to stop to exchange information. The witness said she followed the defendant and observed her throw the buzzball out the window. The defendant admitted to consuming 3 mixed drinks prior to operating the vehicle. Field sobriety tests were then conducted with 6 out of 6 clues on the HDN, 4 out of 8 on walk and turn, and then 2 out of 4 on the one-legged stand. The DIC was read and the defendant consented to breath tests, with the results being a 0.161, 0.157.
So she had alcohol in the car is the allegation, right?
Yes, the witness saw her throw the buzzball outside the window.
And Judge, I do want to point out that she's also 20 years old.
Ms. Molina, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you now not to drive any vehicle that's not equipped with an ignition interlock on it. I send notice to DPS in Austin. Every police officer in the state will know if you're pulled over, you're driving a car, and that car doesn't have an interlock, they're going to take you to jail. Do you understand? Just don't do it. Don't consume alcohol. Don't use illegal drugs. I'm telling you that you're going to get tested. It's not a matter of if, it's a matter of when. If you test positive for anything illegal, including marijuana, THC, gummies, vapes, it's just not going to go well between us. You understand? How do you support yourself? How do you support yourself? Do you have the ability to hire a lawyer?
No.
What do you do for a living?
I work at a hair salon as a receptionist.
Okay. What kind of money do you make a month?
13 an hour at the moment.
Okay. Deputy, do you mind giving her an application? We're going to give you an application for a court-appointed lawyer. I need you to fill it out fully, truthfully, because you're going to swear to it, and then I'll take a look to see whether you qualify. And having you sign a reset, you'll get with Veronica for your bond conditions, and then we'll have you take a seat in the view. Please, ma'am.
This way. All right, bottom of 11, Rivas.
Good morning, Ms. Rivas.
Good morning.
Ma'am, you're charged with theft. Again, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, sir. On August 6th, 2026, an officer was dispatched at 36 Farm to Market, 1960 Road West, which is Kroger in Harris County, Texas, in reference to a theft. Upon arrival, the officer met with the complaining witness, who's the manager, who stated the defendant grabbed multiple items, including alcohol, jelly, and cat treats, and then exited the store without making any attempt to render payment for the items. The complaining witness confronted the defendant and confirmed the items were stolen. The defendant was then detained until the officers arrived. Total value of the stolen merchandise was $37.23, and the defendant was ID'd by her Texas driver's license.
And Ms. Rivas, I'm going to find that there's probable cause to go forward with your case. You are not allowed to go back to any Kroger whatsoever for any reason. Do you understand?
Yes.
If you violate this condition, I will revoke your bond and put you in jail. Doesn't matter how little, how minute you may think it is, just don't pick up any new cases. Do you understand? And do not violate these conditions. Do you have the ability to hire a lawyer? Deputy, we'll give you an application. I need you to fill it out and we'll take a look to see whether you qualify. Can you file, please? No going to any Kroger. All right, please, ma'am.
Right this way.
Thank you. Hang on. a minute.
All right, Judge, next is page 14, Scroggin. Come on up.
Good morning, Ms. Scroggins.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, sir.
Okay.
On August 7, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when they observed a gray Nissan Pathfinder going 85 miles per hour in a 65 mile per hour zone. The vehicle was also failing to maintain a single lane. A traffic stop was conducted and the officer made contact with the driver and the defendant. While speaking with the defendant, the officer observed her to have glossy eyes, slurred speech, and there was a strong odor of alcohol emitting from her person. The defendant admitted to consuming 2 beers prior to operating the vehicle. Field sobriety tests were then conducted with 4 out of 6 clues on the HGN, 2 out of 8 on walk and turn, and 2 out of 4 on the one-legged stand. The DIC was read, but the defendant refused to consent to breath/blood. The blood warrant was then signed and executed. The officer also located a marijuana pen inside the defendant's vehicle during the inventory search.
Does she have any prior DWIs? Do you mind looking? And then does she have a license?
She has no criminal history, Judge.
Okay,
What's the defendant's last name?
Scroggins. Ms. Scroggins, I'm going to find that there's probable cause to go forward with your case. You're ordered not to consume alcohol or illegal drugs, including marijuana or vape pens. You will be tested. If you test positive for either, I will revoke your bond and put you in jail. You understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance. You must also maintain car insurance. If you don't have it, then likewise do not drive. How old are you, ma'am?
24.
Do you have the ability to hire a lawyer?
Yes, sir. I have an attorney, but he said he was supposed to be there this time.
Who is it?
Greg Ramsey.
Okay. I don't see any documents filed on their behalf. So let's do this. I'll have you sign a reset. We'll get you done with all the paperwork. We'll let you wait a while to see if they show up. If they do, great. If not, then we'll give you time to go hire them. Okay? Yes, ma'am. Please.
This way. All right, sir. Page 17, Turner.
Good morning, Mr. Turner. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, sir. On August 7, 2026, an officer was conducting a routine traffic patrol in Harris County, Texas, when they observed a black Chevrolet Cruze run a stop sign at the intersection of Staple Street and Reddish Street. A traffic stop was conducted and the officer made contact with the driver, the defendant. The defendant immediately informed the officers that he had a firearm within reach while he kept his hands outside of the driver's side window. The defendant was then told to exit the vehicle and he complied. The officers then searched the vehicle and located an unholstered AR-15 pistol on the driver's side floorboard. The officer also located 2.09 grams of marijuana inside the vehicle. The defendant was detained without incident. The defendant's dog, which was inside the vehicle, were released to a family member on scene per his request.
All right. Mr. Turner, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons whatsoever. Do you understand? Don't pick up any new cases. Don't endanger my city. It's just not going to go well for you if you do. How old are you, sir? Do you have the ability to hire a lawyer? We will give you time. I'm going to have you sign a reset. We'll have you take a seat while we get the bond conditions. Once you sign them, at that point, you'll be free to go. Okay? Please. No weapons, guys, please.
Yes, sir. Got it.
All right, top of 18, Wilkerson.
Good morning, Mr. Wilkerson. Sir, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, sir. On August 7, 2026, an officer was dispatched to 11111 West Montgomery Road, which is an apartment complex in Harris County, Texas, in reference to an assault. Upon arrival, the officer made contact with the complaining witness who stated the defendant and his girlfriend were arguing in their apartment and creating a disturbance. The complaining witness stated she, her friend, and her neighbor all went to the defendant's door and started banging on it in order to get them to stop. The complaining witness stated the defendant and his girlfriend then exited the apartment and physical altercation ensued between the complaining witness and the girlfriend. During this altercation, the defendant entered and struck the complaining witness on the left side of her face with a closed fist, causing pain. The officer observed visible injuries on the complaining witness, including a large laceration on her eyelid and significant bruising. Both witnesses confirmed the complaining witness's story. The officer then spoke to the defendant and his girlfriend, and they provided inconsistent statements. The defendant was taken into custody without incident.
Mr. Wilkerson, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with this person and not to be in possession of any weapons. I'm also ordering you not to go within 200 feet of where they live or where they work. If you violate this agreement, I will put you in jail. There will be no more PR bonds for you. Do you understand, sir? You have the ability to hire a lawyer.
No, sir.
How do you support yourself?
Work,
What do you do for a living?
the house is making a house.
Okay, what kind of money do you make a month?
I'll make nothing around.
So how much money do you make a month? You said you make $19 an hour? You make around $3,000 a month. Who do you live with? Okay, I'm going to give you the opportunity to go hire a lawyer. It's time. So what I'm going to have you do is I'm going to have you sign a reset. I will have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. I don't know who you have in this life, Mr. Wilkerson, but if I make your bond $10, $20, $30, $50,000 and you don't have anyone to pony up that kind of money, you'll be stuck with me for a long time. There are no mistakes in this life. There are choices. You either make a good choice or you make the bad choice. I don't want you to go anywhere near this complaining witness. You understand? Okay, come on.
Mr. Wilkins, there's no contact. Go ahead and sign for the reset.
No contact, no weapons, no going within 200 feet of where she lives or works. Please.
Page 16, Fran, come on up.
How many more we got?
Just the last one.
Come on. Fran.
Another without an attorney.
Do what?
With one more with an attorney, sorry.
Okay. All right. Do you speak English, sir?
Yes, sir.
Mr. Tran, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, sir. On August 9, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when they observed a black Lexus with no headlights on, and this was during the nighttime. The officer attempted to conduct a traffic stop with the emergency lights activated, but the vehicle refused to pull over and continued to drive northbound. The vehicle eventually pulled into an apartment complex, passed up on multiple safe points to pull over and made 2 turns, and the officer was able to detain the driver, the defendant. The officer observed the defendant to have an apartment access card in his hands when he detained him. The officer also observed the defendant to have glossy eyes, unsteady balance, and there was an odor of alcohol emitting from his person, though the officer didn't think he lost use of his normal faculties.
Wow. 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 So how far was the alleged fleet?
I believe it's 0.3 miles, Judge. Actually, they don't even clarify it in the notes. It just says he passed up on multiple safe points and he made 2 turns. I agree, that smells fishy.
That's funny. Let's pull up the code. Let's see what it says. Thank you for your honesty, though. All right, let's pull it up. So a person commits an offense if the person operates a motor vehicle and willfully fails or refuses to bring the vehicle to a stop or flees or attempts to elude a pursuing police vehicle when given a visual or audible signal to bring the vehicle to a stop. Do we know, was there a visual,
The emergency lights were on and the sound was on.
okay, I mean, distance is not a factor as far as penal code is concerned. It's whether you stop or whether you don't, right? So,
I also want to clarify, he turned on his hazard lights as they were pulling him over, so he might have just been trying to signal to them that he was trying to find a safe spot in order to pull over.
but you said that there were 2 other locations that he could have, right?
Yes.
That's what the officer said?
Yeah, he turned
I mean,
on-
yeah, it meets it for now. I mean, it may not be beyond a reasonable doubt, but for purposes of probable cause, I think that there's enough to go forward. Does Mr. Tran have a license to drive?
Yes, he did.
Mr. Tran, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. You understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance. Those are also conditions for you. Don't worry about filing it. I'm going to monitor him because I don't want to make sure he's not consuming. How old are you, sir?
24.
How do you support yourself?
I work as a surveyor electrical.
Do you have the ability to hire a lawyer?
No, sir.
Okay, Deputy, do you mind giving me an application? I'll give you an application. I need to know everything about you, how much money you make, where you live, what kind of cars you have, and then I'll take a look to see whether you qualify. Do not leave until you sign the bond conditions, and then we'll have you sign a reset. Okay? Please. Eric,
Morning, Judge.
do I know you?
It's been a minute.
I know. How are you? Great to see you, man. What's new?
I got Mr. Romo.
Romo.
Docket,
Jail or bond?
bonds.
Is he here?
It's my understanding he was sent to get a drug test.
So he failed to show.
He failed to do his drug test last week. Had a PVR. He showed up to court today and was sent to
Okay.
test today.
Romo. So we're in trial now.
Yes, that's why I just wanted to say hi.
Yeah. So you know the drill. Admonish him and tell him if he ever misses again, he will go to jail. I'm not going to do this again. That depends on what happens now, obviously. So I guess just keep me in the loop, and we'll go from there. Yeah, for sure. You too. Come on.
We're about to start trial, so I was trying to.
Yeah.
It's a BVR, it's a 1, positive on call. Here in Los Angeles, he was sent across the street, they worked this morning. I asked the court to try and launch him.
Veronica,
He's still current in custody.
I know, but on Mr. Sanchez, can you, let's amend the bond conditions to put a scram on his ankle now? So we know he's not, and any further violations,
Judge, if I may, he had to start his job that.
he has an unlawful restraint, an interference, and a felony assault. He tests positive for alcohol. He's lucky he's not going into jail. I don't give a rat's behind. I told him not to drink. He's got a bond violation. He's either going into jail or he gets a scram. Really. If we enable, what happens?
Judge, I'm not
Right.
challenging the court, I'm just saying that his new job is very labor intensive, and I just want to make sure that the scram stuff that would hinder him from doing it. If it's not, I don't mind. I'm just making sure. Okay, then that's.
Actions have consequences.
Certainly, Judge.
So I hope I don't know. Tell him not to violate again. Otherwise, it's not going to go well between us. Okay.
For the scram, can we,
Yeah, I'll pay for it. Don't worry.
thank you,
Yeah. Okay.
that excuse?
Yeah.
It might probably be excused.
Well, once and assuming he doesn't test positive again. I don't know about that. We sent him a test, so hopefully
If he does. would you like-
then we'll have, no. Then we'll have to have a whole other hearing.
Okay.
Yeah. Okay. All right. Come on up.
Oh, you're not dealing with the case number?
What is it?
It's 260
Okay.
697.
On Allen?
Yes, sir.
Okay.
You know, I pushed yesterday to send it for trial. We got his trial date for July 6th.
He didn't show up.
Quickly yesterday, I was there.
He didn't show up, you wanted to go to the side, the one that said.
This is the one that just left.
Right, but he had gotten a trial date from the long night, and he let me know, so I thought it was MIA that he was gone. I never got him to sign a reset or anything, I had no idea it was being set.
Is the defendant here now?
Mayor.
I'm not gonna, when he gets here to sign the reset, then I'll reinstate it. So if you bring him next week, then I'll reinstate it for you. Okay? All right. Craig,
Sir, may I approach?
please. Yeah, we're about to bring a jury in. So
Yes, sir.
Deputy, after this, we need to get the jury.
I'm here on Angel Melendez. I know that he had been called up before, but I'm going to be his attorney. I was just going to see if I can make a quick argument on PC and have him assigned to a court within Interlock. He's not going to drive.
Well, I don't know that, but okay, go for it.
So with the PC, basically it's saying that he was stopped eastbound on Fuqua and Humor.
He stopped in a moving lane of traffic.
facing east. Yes, sir. And so my argument is that that's not inherently an illegal activity that should merit the attention of the police. That's
He stopped in a moving lane of traffic. He's impeding traffic. It's obstruction of a highway.
maybe, but they didn't allege anything.
No.
And the only thing that
Yeah, they did.
alleged is they said that there was a record driver who they had talked to, but they didn't allege that that was a reliable person, which is what they're supposed to be. They didn't allege who that person is. And so they're relying upon some unknown third party, even in the detention report, as far as any indication that the vehicle was or was not in part.
Did the officer see him as such?
Judge, they saw the car remain stationary and they walked up to the vehicle and saw him asleep behind the.
Yeah, I think there's PC.
Okay.
Yeah, and I nevertheless, he still has a car. I want him to have an interlock on.
He's gonna be in Waco, Your Honor. So he has a job that's in Waco, and so the car is gonna remain here in Houston, so he won't be able.
But how do I know that? Do you know how many people ask me for a portable device and we still catch them driving and we put them in jail anyways?
I get it, but if he's on the portable, he's gonna be blowing 3 times a day, and the car is gonna be, we can have him sign a no driving affidavit, Your Honor, that's fine. We can do that. The
If he
problem
still
is
has
if we have the
access.
interlock, what'll happen is pretrial servitude is gonna get angry because it's never gonna blow into it because it's in Houston. And
And then he gets a bond violation.
right, so it's impossible for him to have the car. If the car is in his parents' name, he doesn't have access to his car when he's in Waco. They were letting him use the car while he's.
Bring me proof of what he's doing in Waco. Bring me proof the car's not in the parent's name, and then we'll talk. But I'm not going to take his word for it. Oh, hey, I'm not going to drive because we see way too much. Sure, of course. Yeah, anytime.
Yes, sir.
Yeah.
I didn't want to delay what y'all are trying.
Don't worry about it.
Yes, sir.
You're good. Okay. Yeah, take your time. We'll be here for a while. Counsel, come on up.
Morning, Judge. I'm here on Mr. Bella Messler.
Messler. Jail or bond?
This will give you all Judge. She's not.
Messler, come up.
She's not from Judge.
Oh, I'm revoking her bond then.
Judge, she's currently in the hospital, as far as I know, but she had a stroke. Officer sent her this photo and said she was being taken, to get some.
Show me.
Nations done, Judge.
Show me what you got.
Just a photo from which can be held. I spoke with her about coming in appearing today for the bond violation.
And this don't even have her name on it.
I understand, Judge. She sent me, I spoke to her on the
Yeah.
phone. All she said is she's in the hospital right now.
Sorry.
Okay, do you want to? She had a court for next week, Judge.
No. She's got bond violations. It's the DWI second. She's not here. I'm revoking the bond. When you get here, we'll talk. But until that point, I can't.
I understand, Judge.
Yeah. Okay.
All right.
Do you want to stay on? Do you want to withdraw?
No, stay on, Judge.
Stay on? Okay.
The bond violation is just never getting a toxic interlock device.
Yeah, that's a big
She's
deal.
not driving, Judge. She doesn't have.
Whoa.
She stays-
Bond conditions are bond conditions. You can't just, okay, I'm not going to drive, so I'm just not going to get it.
I
You
understand,
can't.
Judge, but she's in a shelter. She lives in a shelter in Galveston, doesn't have access to a car. So, I mean.
So you come-
I believe we asked you for a portable originally. You didn't want to do a portable. You said that they're like anyway, is what Mr. Lee told me, Judge.
Get her here and we'll talk. But until that, yeah. Thanks. Mr. Whiteside, come on up.
Mr. Martinez or
Say it again. Who?
Mr. Martinez.
Martinez. Martinez, come up. You speak English, sir.
Yes, sir.
So you're charged with driving while intoxicated. You're facing up to a year in jail because of the high blow. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay.
On August 9, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when he observed a Ford F-250 remaining stationary in the middle of the roadway. The engine was still running and the hazards were on. The officer approached the vehicle and banged on the window multiple times, but no one responded. The windows had a dark tint, so the officer couldn't see inside. The officer then called the tow truck. The tow truck driver observed someone in the vehicle right before he was about to tow it. The officer then approached the vehicle and the driver and the defendant exited. While speaking with the defendant, the officer detected an odor of alcohol emanating from his person. The defendant stated he fell asleep behind the wheel. Field sobriety tests were then conducted with 4 out of 6 clues on the HGM, 1 out of 8 on the walk and turn, and 1 out of 4 on the one-legged stand. DIC was read and the defendant consented to breath tests with the results being a 0.154 and a 0.15.
Did you say there was an accident? Or
No, Judge. He just observed the vehicle remaining stationary in the middle of the roadway with the hazards on.
okay,
Judge Man.
sure.
First of all, I think that's inaccurate. I don't think he said he fell asleep behind the wheel. He said he fell asleep. There's nothing.
So he's asleep at the wheel in the middle of a moving lane of traffic.
No, he's not a significant judge. There's nothing to establish that he's operating the vehicle.
So he's in the car?
What's that, Judge?
He's in the car?
But we don't know where he's could be in the, it's not illegal to be drunk in the back of your car asleep. It's not an arrestable offense.
Well, I mean, if you're in a moving lane of traffic, right, that's maybe an issue.
But not an arrestable offense. There's nothing to indicate operation. The vehicle was running. Nothing indicates he was in the driver's seat. Nothing indicates his foot on the brake. Nothing indicates the car was in gear. Nothing indicates any admission that he was operating the vehicle by himself or any witnesses or the tow truck driver or the officer, Judge.
So, but he's in the middle of the road.
Yes.
He's alone.
The vehicle's remaining stationary in the middle of the roadway. The hazards are on. The officer walks up to the vehicle, knocks on the door multiple times. No one answers. Tow truck driver, he's about to tow it off, and then he sees the defendant. And then he says, okay, stop, talks to the officer. Then the defendant exits the vehicle.
Also, Judge, we have no timeline. We don't know how long the vehicle was there.
I get it, but this is just probable cause, which is a very low standard. It may not be enough for a reason beyond a reasonable doubt, but he's in the middle of the road. He's alone. The car's on. Is it night? Or, I mean, it really doesn't matter. Just, I think that there's enough.
Probable cause, Judge, don't we need to establish he was operating the vehicle?
He's in the car. He's in the middle of the roadway and he's alone. How else? We have no other evidence that someone took off, someone else was driving. He's alone. He's in the car. He's in the middle of the roadway. If he was in a parking lot, that may be a different question. Could be sitting at Lowe's or, you know, that may be a different call. But when you're in the middle of the roadway, you got there somehow, right? Yeah, Mr. Martinez, there is enough probable cause to go forward with your case. Does he have a license to drive?
Yes, Your Honor.
As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication, and I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
When I mean no alcohol, I mean no alcohol from any source. Cakes, candies, foods, gums, energy drinks, it doesn't matter. I just don't care. Just don't use. I'm going to test you for illegal drugs, including marijuana as well. If you test positive after 50 days, it may not go well between us. You understand?
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and or liability insurance. You must maintain liability insurance as well. Otherwise, just don't drive. Because you have a lawyer, I will waive your appearance. You must stay in contact with Mr. Wycheck. He'll tell you if and when you have to come back to court. For now, we'll have you sign a reset. You'll get with Veronica free bond conditions, and then you're free to go. Please, guys.
Just a heads up, we have two arraignments.
Okay, come on up. Yeah,
Hi, Judge. I'm here on Veronica.
okay,
Okay, can I?
go for it.
So third, 728 camper event, alcohol not detected.
But a tamper event
Right.
means a lot of
Right, I'm
crime.
gonna get there.
Okay.
So at 10:46 PM, replace brake equipment alert issued by Scram Company.
Oh,
They issued the replacement. It says here, this is basically what's on. Defendant has been complying with 4th of July. My client got the notice. He went the next day and
got notice of what?
sorry?
Got notice
He
of
got
what?
notice that they wanted to, that something was wrong with the bracelet, to take it back. And he went the next day immediately and got the egg monitor replaced. Furthermore, the alcohol is not detected, and furthermore, this is all what they said, what you all are saying. The defendant has been complying with sort of device. There's no alcohol whatsoever.
When we have a tamper event, typically what that tells me is someone is manipulating the device in a manner to evade detection. They may put a piece of paper, they may put a tissue, they may put something in between the ankle and the device itself. So what I normally will look to is how long was the tamper event? Was it 10 hours? Was it 12 hours? Was it 2 hours? Was it 15 seconds where it kind of just got loose, where they say that is a tamper? That's, to me, what is important. Yes, it may not test positive for alcohol, but for you putting something in between the device and your ankle. I don't know. Veronica.
Yes, so it looks like,
Peralta, come up.
It was out from 6:23 a.m. to 8:35 p.m. So a 14-hour window.
However, during that time, we drew portable device and it was already.
Did he blow into a portable device at any time during that time? What time? Could he conceivably have consumed alcohol and we wouldn't have known about it? Because typically the blows are in the morning, in the afternoon, and then at night.
According to what we got from the pre-trial, no alcohol was detected.
Because there's a 14-hour window where it couldn't detect his skin.
Judge, the fact that they called him up and they.
Anytime there's a tamper event, they say, come on in so we can figure out what's going on. Anytime there's it doesn't,
And we did have results. So on that same day, he blew into the device at 7:51 a.m. On 8:20 p.m. it was missed. And then the 10:03 p.m. it was an invalid. Oh, wait, here it is. It was cast. It was
so, but he only blew one time that day?
he blew twice that day. Once in the morning at 7:51 and then again.
I'm sorry, I'm revoking his bond. It's a fourth bond violation and it's 14 hours. It didn't have it wasn't touching his skin. It should not do that. So.
He was negative both times.
Yeah, yes, you blew at 7 in the morning, then at 8 in the morning, you can have a drink, and then you blow at 8 at night, it's not going to test positive. You're right. But in the in-between, what do you want me to say? It's a fourth bond violation. I mean, I can't just continue to, no, it should not be a 14-hour window. I do this because we've had bond violation after bond violation with you, Mr. Peralta, and it's over today. You will go into jail. I'm revoking your bond. It shouldn't be a 4-hour window. I'm sorry. It's a fourth bond violation. I cannot continue to enable a 14-hour window where you're evading capture. It's not cool.
We went to the other bond violation. That's why you never focused on, Judge.
Right. And it continues to happen. And we have a 14-hour window. You were going into jail today. Goes with you.
I'm not bringing the officers. I promise and I swear.
You know how many people swear to me? You know how many people tell me I have a great head of hair?
Sleep at 6:23. I was asleep.
He goes with you. Sorry, it's a 14-hour, I can't just continue to enable it, man.
Kind of bond. I mean, seriously.
His bond's now at $100. I'll set it at 5,004. Okay? Yeah. All right, coming up. Hey, what's up?
Antonio Celestino.
Here we go, another one. Celestino, come up.
Mr. Celestino has two devices. He has an interlock and a scram device. The interlock has been wreaking havoc with the contact security system of the vehicle. And it's currently, his car is completely inoperable. He has to save the money to tow it to the smart start for them to try to fix it. But he's had the scram on the whole.
If you can find the scram device, it's, the one violation is because his device went into lockout, 7:23, and he never went through the response rate.
I mean, how do I know that he's not operating the car or doing, I mean, really?
Well, the car is completely inoperable. That's why.
How do I know that? Am I supposed to take someone's word for something? This is a court. In courts, we run on proof, not on the gospel, not on spoken word, not on hopes and dreams and promises. We work on proof.
He did specifically request both the smart start on the pre-trial.
I'm going to give you the benefit of the doubt. And what I'm going to do is I'm going to roll you until Monday. And I want you to bring me proof somehow that your car has been inoperable for the last month. Otherwise, we will have another hearing as to why I shouldn't revoke your bond. But it's unacceptable that you just do whatever the hell you want to do and ask for forgiveness after the fact. We don't operate like that, Mr. Celestino. And you have literally had bond violation after bond violation. I'm giving you the benefit of the doubt.
The first bond violation.
I have had.
I mean, that's what the report has.
This is his second DWI within the same year. He had a DWI dismissed earlier this year. With that other DWI, we had literally bond violation after bond violation, and I think I had to jail him at least twice for a bit different bond violations. And now we're here again on another DWI in the same year with bond violations again. And this time, a month without it. The only thing I wanted is to ensure that if you are driving, that you don't have alcohol on board. And now we will see you Monday. Bring me proof. We don't work on the gospel. Do you understand? Okay. All right. We'll see you Monday.
Right this way.
Great.
Sir,
Come on up.
so I'm reapproaching on how Linda's, I sent you and the prosecutors an email showing that he's working at the new job in Waco, Your Honor, all the messages that he has within relation to.
I don't have a problem that he works in Waco.
Yes, sir.
I just want to know that he's not going to get in a car and drive with alcohol on board.
He sent me a copy of the title, which I just received, Your Honor, so I didn't attach that to the email, but it shows that the owner is Eric Alejandro Fuentes Gonzalez and Monica Latricia Salas Morales. And so the car is not his car. He's not going to have access to the car. The car will be in Houston. And
How do I know
he's not
that?
going to have any vehicle. Like I said, my request is.
How's he getting, so he's going to Waco, right?
He's riding with a coworker up there, right? And so they're sharing a hotel room and a coworker is driving, he's with somebody else. And so that's the only way that they have any place to stay while they're doing construction. Okay, so we're gonna be riding with somebody else. He'll sign a no driving affidavit, it'll be tested every day, he's gonna report his device. Which I think gives us,
What's his last name?
Melendez, Your Honor, he's on docket today.
Melendez, come up. So, hey, guys, do me a solid, please. This is Mr. Melendez here. He's going to sign a no driving affidavit. So in a month's time, what I'd like to do is I'm going to put him back on the docket and I want to run a driving record to see if somehow he's been driving. Because if he is, we'll have a contempt hearing. You're going to be signing an affidavit with me today, promising me you're not going to drive. I don't care what the hell goes on in your life. I don't care that a kid has to go to the hospital. I don't care that you have to go to work. I don't care that you need groceries. I don't care that Bambi has to go to the hospital. There's no justification after signing this affidavit that you drive whatsoever. If you do, I can have a contempt hearing and slap you with 180 days every time you drive. And if I want to really be obtuse, I can stack it. Do you understand? It doesn't matter what the excuse is. If you're signing and promising me you're not going to drive, do not drive. The only thing that you need if you want to drive is you must have an interlock. I'm sending notice to DPS in all centers that every police officer knows that if you're caught driving and that vehicle doesn't have an interlock, they're going to take you to jail. Do you understand? Do you see how many people we've put in jail today?
Yeah.
I'm not asking much. I just want my public safe, man. All right. So he'll get a portable device. He'll have to blow at least 3 times a day.
Yes, sir.
If you fail to blow in this device, a bond violation report will be submitted and we will have a hearing to determine whether to put you in jail or not. Do you understand? All
The
right.
only other thing I had to ask Judge on this was because he's gonna be in Waco, if he's called in for a random test, can he get a test somewhere?
He has to be at Quest Diagnostic.
Okay.
Nowhere else.
Yes, sir.
Okay.
So just that same
Yeah.
thing within 24 hours, or whatever, go to the question.
No. Not within 24 hours. It's within 4 hours.
Oh, okay.
Yeah.
Okay. Yes.
Within 24 hours, it gets out of your system, whatever it may be.
Well, most judges.
That's why.
Would they let you know before, like a day beforehand?
No, they'll let you know the day of. You're going to have to reach out to pretrial services and say, hey, man, you're up for a test. And then you got to just go. What I would do is find a Quest in Waco, make sure you know where they are and what their protocol is to be able to take a test rapidly. It is your responsibility to take the test, to get that result to him, and he's going to get it to us. If you fail to do it, I'm going to haul you right back over here and we're going to have a hearing. All right?
Thank you.
Okay, good luck.
Thank you.
Hi. Yeah.
Morning again. I'm reappointing Officer Diego Sanchez, the one that.
Everything okay?
That's alcohol on the test.
Oh, he tested positive for alcohol.
The court did order.
Come up,
The court did just order a spraying device, prior to judgment.
come up.
Before.
No. If he tested positive for alcohol now, he probably drank, not like just a couple hours ago.
Judge, if I may.
Sure.
Just the court, this is our first bond violation setting. I just asked the court.
It's a second bond violation.
Judge, this is our first violation setting. I just asked the court consider since it did order a spraying monitoring device, as well as Mr. Sanchez does have court Wednesday of next week. If the court could order Mr. Sanchez, not just the device, but also to mandate him to AA courses, and we could forward his matters in this court, we can report next week, Judge. I would just respectfully
Hey,
request the
Deputy.
court not revoke
Deputy.
his bond in this matter. Judge.
Sorry.
This is Judge, this is our first bond violation.
It's
setting
not
in this
though.
court.
It's not. And had he not tested positive now, then I would have let him go. But he failed to go test. We send him now for a test and he tests positive for alcohol. He failed to go take the test. What was a bond violation that got him here?
That he tested positive for alcohol.
Oh, I'm sorry. He tested positive twice for alcohol. No, you're going to jail, dude. Sorry.
Judge,
It's 2 bond violations. He tested positive twice for alcohol. If I continue to enable, what does that mean?
Judge, I'm not asking you to enable the court did order a spraying monitoring device to examine which we're asking to grant him 1 week. And if there's an issue from now until the setting next week, we're going to revoke his bond then. This is a person who frankly has not had to deal with this sort of bond condition before. I'm just respectfully requesting the court consider the option of putting the spraying monitoring device on, mandating him to go to AA courses. Because he has court on Wednesday of next week, we can also mandate him to return to this court and check into the court if there's any issues that we can revoke the bond then. Judge, I would just ask the court consider that as an option, given the
Can't.
situation.
He tested positive for alcohol today. That's just, I tell you what to do. You're here, you've got 3 violent cases. I'm not asking for much. All I'm asking you to do is don't drink alcohol. And you literally, I send you at 8 in the morning to go take a test and you're testing positive for alcohol at 8 in the morning. What the hell does that mean?
Judge, I understand.
Stop. I'm making the decision. You're going to jail. And hopefully now we will get Mr. Sanchez, I hope now we will get your attention. But you cannot continue to violate condition and expect good things to happen. Do you understand? It doesn't work like that in a court. It goes with you. Sorry. I'm setting the bonds both at 5,000 and 2. If he's not able to bond out, then come back and we can talk. But I can't just continue to, it's just too much. You're testing positive for alcohol at this early hour? Really? Sorry. Yeah. Hey, come on up. Hey, we need to hurry because I got a jury waiting. I got to bring him in.
Real quick, and
Tell me.
Mr. Hines is here. You asked him to come back to do his PTI from a few days ago.
3504 on the bill here. And then I'll do bail orders here momentarily. Who?
Damon Hines. We were here the other day. He had a mental health PTI assessment he needed to complete. He told him to go by yesterday and provide.
Oh, did he get it done?
He went right after court. I provided it to Veronica and he stayed. He got it done. We're just waiting on mental health to confirm.
Okay.
Correct, Judge. That's all I'm waiting for.
So let's just wait a bit for them to, yeah, okay. All right.
Judge, can we get an arraignment up there?
Yeah, come on, bring it.
All right. Page 4, Herrera. Come on up. Go on the other way first.
You said page 2?
Page 4, there are 2 cases. One was transferred from court 6.
So it's not a new case.
No, not in.
All right, coming up, Mr. Herrera.
Yes, sir.
Hey, guys, we're going to start in 2 minutes. All right, bring the jury back. All right, Mr. Herrera, you're charged with, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
Yes,
All right.
On August 8th, 2026, an officer was conducting routine traffic patrol in Harris County, Texas, when they observed a silver Pontiac with a defective stop lamp. A traffic stop was conducted and the officer made contact with the driver of the defendant. While speaking with the defendant, the officer observed him to have bloodshot eyes, slurred speech, and there was a strong odor of alcohol emitting from his breath. The officer also observed in plain view an empty can of Modelo on the passenger side floorboard. FSTs conducted with 6 out of 6 clues on the HGN, 2 out of 8 on the walk and turn, and 0 out of 4 on the one-legged stand. The DIC was read and the defendant consented to breath tests with the result being a .088 and a .090.
Did you say it's 6 out of 6 on the HGN?
Yes, sir.
Okay.
And then the officer also located an unholstered handgun in the center console of the vehicle during the inventory or search.
Victoria,
Yes, Judge.
why was it transferred to us?
Because we had the lower cost number. It's just.
Oh, I see.
Filed one day.
Okay, got it. All right. Guys, does Mr. Herrera have a license to drive, please? And are you alleging that he had alcohol in the car?
Yes, Judge, it does say that they located a can of Modelo on the passenger side floorboard. And then in terms of his license,
Yeah, but
I don't believe it's enhanced, Judge.
Eligible judge? He has an eligible driver's license.
Mr. Herrera, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand? I don't care what your excuse is, just do not use. If you have a problem with drugs or alcohol, now is the time for you to address it, because if you don't, I will do it for you, and I promise you're not going to like the way that I do it. You understand?
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and or liability insurance. If I find that you're driving without either, then likewise into jail you go. No weapons while you're on bond. You understand?
Yes, sir.
All right. You have the ability to hire a lawyer. How old are you, sir?
26.
What do you do for a living?
I am a choreographer.
You're a choreographer.
Yes, sir.
What kind of money do you make a month?
It can depend, it varies. Depends how hard I work. It could be up to maybe four grand.
Okay, we're going to reset your case to give you time to hire a lawyer. You need to hire a lawyer for this. You're facing up to a year on the gun case as well. Do you understand?
Yes, sir.
Okay, I'm going to have you sign a reset. We will have you get with Veronica for your bond conditions, and after that, you'll be free to go, sir.
Okay.
Come on.
Thank you.
You got it.
All right, Judge, next is.
Okay, bring it. Let's do it. This is the last one, right?
Yes, Judge, top
Okay.
of 10, order, come on up.
Right, so depends on the department. Yes, sir.
Good morning, Mr. Porter, right?
Yes, sir.
Mr. Porter, you're charged with failure leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
The officer spoke with the complaining witness. The complaining witness stated that on December 12, 2024, her daughter had contacted her via public service and stated that someone had hit their 2020 Kia Optima as it sat parked unoccupied at Decaney High School located at 22351 Imperial Valley Drive in Harris County, Texas, and left without leaving any information. The complaining witness's daughter collected the Florida license plate and obtained a video of the vehicle driven by the defendant. The officer obtained security footage of the parking lot and observed the defendant exit the vehicle. Decaney High School staff identified the defendant as a former student known as Thomas Porter. Defendant's mother confirmed that the defendant was driving the vehicle and noticed there was damage on the vehicle. In 2 separate interviews, the defendant admitted to reversing into the complainant in the Bamwell Road parking lot. The defendant stated he did not observe significant damage to the vehicle, so he left. The complaining witness was able to provide an official estimate from a body shop detailing the cost of repair to his vehicle to be $2,918.82.
Okay. Does he have a license to drive? Porter.
This is Porter.
Does he have a license, please?
Just driver license number, but I'm double checking to make sure it's still present.
You said this was at a high school, right?
Yes, Judge. Decaney High School.
Okay.
Yes, Judge, you just have a driver's license.
Okay. Mr. Porter, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to go back to this high school, not to be in possession of any weapons, and not to drive unless you have a valid Texas driver license and liability insurance. If you drive without either, then I will revoke your bond and put you in jail. There will be no more PR bonds for you. Do you understand, sir?
Yes, sir.
Are you working at this time? Do you have the ability to hire a lawyer?
I get paid from the tax and disability, so.
Okay. Did you want to apply for a court-appointed lawyer?
Yes, sir.
Okay. Deputy, do you mind giving me an application? Are you currently in the military right now? Okay. Mr. Porter, I don't know who you have in this life, but if you endanger my community and I have to put you in jail at a $10,000 to $50,000 bond and you don't have anyone to pony up that kind of money, you're going to be with me for a long time. It takes damn near 9 months just to get a 911 call. Do you understand? I'm not asking much from you. I want my city safe and I'm going to do it at all costs. All right? Okay. We're going to have some bond conditions created for you to sign. Do not leave until you sign. All right? Please.
One more time, Judge.
Last time, because I got to bring a jury in.
Are you gonna require any other bond conditions or anything?
Same bond conditions will continue. Yeah. All right. Come up real quick. The last thing, and then we're bringing the jury in.
Judge, I have to walk through, I know Cindy approached the court this morning on Francisco Samano. Can I get your call number?
Yeah.
It is 263.
Okay.
3789. Thank you, Judge.
Samano, come up.
Go to that side.
He doesn't see it.
Oh, you don't even have a translator though.
No, she's here.
Okay. Tony, can we borrow you real quick? You are Mr. Samano.
Yes.
So you're charged with driving while intoxicated. It is elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Yes, sir. On August 7th, 2026, officers were dispatched to a crash major. Upon arrival, they met with the defendant to gather his identifying information and statements about the incident. The officer then met with the witness, who stated he was the driver of the 2023 white Honda HRV and was involved in the crash with the defendant's vehicle. The witness further stated he observed the defendant exit the driver's side of his black Cadillac and attempt to run away from him. The witness stated he observed the defendant fall to the ground, so he used both of his hands to hold him down to prevent him from running away while speaking with the 911 dispatcher. The officer then spoke to the defendant, and while speaking with the defendant, he observed him to have bloodshot eyes, poor balance, and a mild odor of alcohol was emitting from his person. The officer then detained and patted down the defendant and put him in the back of the patrol vehicle. Field sobriety tests were then conducted with 6 out of 6 clues on the HGM, 6 out of 8 clues on the walk and turn, and 3 out of 4 clues on the one-legged stand. The GIC was read, and the defendant consented to breath test, with the results being a .157 and a .154.
Guys, does Mr. Samano have a prior DWI and or a license to drive? Do you guys need the cause number?
Yes, Judge, please.
It is 2633789. Thank you.
He does have a Texas driver's license, Judge.
Okay. Any prior DWIs?
And there's no criminal history, Judge.
Okay. Mr. Samano, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
Put me in jail?
I'm telling you not to consume alcohol or illegal drugs. These are your bond conditions. You are not allowed to drive unless you have a valid Texas driver's license and liability insurance in your name. If you violate these bond conditions, then I will put you in jail. When I mean no alcohol, I mean no alcohol from any source. When I mean no illegal drugs, it includes marijuana, vapes, gummies, anything that would cause you to test positive. If I put you in jail, I will not give you any more PR bonds. Do you understand?
Yes.
I will set your bond at $100 and I will give you a PR bond, but this is not a revolving door and you will not get PR bond after PR bond. Do you understand?
Yes.
Okay, we will have all, sign all your conditions and then after that you'll be free to go.
Thank you, Judge. May we excuse?
Yeah, thanks.
Judge, what was the bond?
so much.
$100. Okay, Ms. Child.
Good afternoon, Judge. I had Javon Wally and Travion Williams that both had BVRs. I don't know if you've spoken with them. I have.
Come up, Mr. Riley. You were on bond for a very, very serious felony. While on bond for that felony, you pick up a violation of a protective order. The only thing I ordered you not to do was go out in the middle of the night. And here we are. I have a bond violation with you where you were literally out over and over and over and over. 3:57 a.m., 2:16 a.m., 4:20 a.m., 1:08 a.m., 3:58 a.m., 11:33 p.m., 11:15 p.m., 11:33 a.m., 4:16 a.m. Ms. Childs, tell me about your client.
Yeah, he was telling me something about his sick child. I think his sick child has been in the emergency room for the past couple of weeks, and I think he can add more color to that. Not excusing him violating his bond.
Do you
but I
have any
know
proof
he's
of
been
that?
out of that.
I'm trying to tell you, so I've been getting calls from preachers saying that, like, they've been calling me when I'm literally in the house saying, where are you at? And I'm telling them I'm in the house. I asked them, can they show me where have I been going? They told me they couldn't tell me, they couldn't tell that. I tried to get more information about where am I going, about where.
So you go to the hospital at 2 a.m. and then you're back at 3:26 a.m.? Is that what you're trying to tell me?
I only went to the hospital one time.
No,
I have here.
I think, Judge, he's telling you that it's showing that he's not at the location and he is in the location. He's asked pretrial services to show an exact ping of where he is and they're unable to do it. So it's reading that he's out when he's in.
That's what I'm
So these conditions came from the magistrate and he has a curfew device. He does not have a GPS device, which is why we can't pinpoint the location. We just see that the device is leaving the house and entering the house.
I don't know what to tell you. Do you have proof that you went to the hospital?
I mean, I can call my mom.
No. Where did you think you were coming today? To the beach? You were literally out over and over and over and over. You were given a curfew and you were violating that curfew over and over. If you know that you have a child that has to go to the hospital, you contact your lawyer and you say, hey, look, this is a situation. Can you reach out to the court and let them know that I've got these issues?
I did. I contacted my lawyer and told him my baby was in the hospital. I never went to the hospital.
When? Oh, so you didn't even go to the hospital?
No, I did, but the next day I came back. The preacher called me again, asking, you were out last night, you were out last night. I never went. Like, I don't go nowhere. When 7 o'clock hit, I'm in the house. I don't go nowhere. I don't leave nowhere.
How do we have proof that he's out?
Because the device showing that he's leaving the house and then it'll show whenever he re-enters the house. So the device has a pinpoint location of where the house is. So when he leaves the house and it passes that line, that's when we get the alert.
Yeah, can I ask something about that, Judge? Is the line like at the mailbox or is it at the front door? Because he has been contacting me constantly, like I'm in the house. Like ever since I've been appointed, he's contacted me almost daily.
I understand that, but the fact remains is that he's out in the middle of the night. And I don't want you out in the middle of the night. It's not gonna go off for giggles, man.
I'm just trying to see, like, can y'all please show me where have I left the house?
It's not gonna happen because the monitor's not there to track your location. It only tells me when you're going in and out. All I know is that it's over and it's over and it's over. It is 7:22, 7:30, 7:31, out at 4 a.m.
I don't know.
8:1, 8:2,
Is it me walking?
8:3, 8:4, literally every single day. You have 1, 2, 3, 4, 5, 6, 7 bond violations. At a minimum, you're literally going out every single day in the middle of the night. Mr. Riley.
I'm trying to, like.
Mr. Riley, Mr. Riley.
That's why I've been contacting my.
It's over. It's over. It's just way too much.
That's why I brought the box up. She told me to bring the box with me. You feel me? I don't know if it's me going in my garage. My granny's a WFC. I'm in and out.
At home means at home. It doesn't mean the garage. It doesn't mean the mailbox. It doesn't mean this. Home means home. And there's nothing that you can justify to leave, not even going to the hospital, Mr. Riley. No, you're going to jail today. That's what's going to happen. It's just way too much over and over and over.
I asked, then preacher told me they was going to try to send her like the map from where I'm going. I still haven't got the map, so Mister, I don't go nowhere, sir.
Pretty sure I was about to say that.
No, see, that's what, I got the messages between my lawyer. She said that if I needed to call my lawyer so she can contact preacher and they can send her the map. I just called them yesterday before I told them all of this. They told me when I go to court, I needed to bring the box with everything. Every time they called me and told me why are you out, I told them I'm literally sitting in the house. I'm sitting in the house. Every time they call me, I contact my lawyer. I don't go nowhere. I don't do nothing. All I do is help my grandma and do stuff with my baby and go to help my mom at the daycare. I don't go nowhere. I don't leave out the house. I don't do none of that stuff.
The evidence points differently.
Can you show me where have I been going?
I've already answered that question for you and I'm done. You're on bond for a felony assault. You've picked up a violation of a protective order and now you continue to violate bond conditions at least 7 or 8 different times. So I would find by clear and convincing evidence that you refuse to comply with bond conditions. You were out on around $50,000 in bonds and you knew, or you should have known, when you were given the conditions, this is what you can and can't do. Stop! If you have any questions, you reach out to your lawyer. If that doesn't work, then you come to court. You just don't do what you want to do and ask for forgiveness after the fact. Courts don't work like that. It goes with you. This is not up for discussion. Who is your second guy, Ms. Childs? Who is the second one?
Williams, Judge,
Fabian Williams, Judge.
stage 18, he came back negative.
Come up.
So,
This is Mr. Williams.
yeah. So recent history on 7/27, he was positive for THC. On 8/3, he was a no-show, and that was the BBR. And so today he tested negative.
Good job.
And can I say something about this judge first? So on 7/27, he talked with pretrial and he let them know that he was going to test positive before he even tested because of, I guess, whatever marijuana he had ingested prior to this case.
I'm continuing his supervision. He's good. He's okay.
Okay.
Yeah, he's good. Great. Just don't miss it again. Please. I cannot continue to enable people. I have enough drama in my life. I don't need any more. Every time you miss a drug test, it just, it's going to go downhill. I'm happy that you tested negative today. Just keep it up. Do not use. A lot of this life is who you hang out with. if you hang out with other people who are using, they may not be on bond. They're not going to care for you. They just want to party with you. If you do this and you test positive again, it's not going to go well, or it may not go well between us. Do you understand? Just stay in contact with your lawyer. Do not pick up any new cases, all right? Okay, man, good job. Please. We'll get you out of here.
This one was supposed to have 2 weeks for a job. My first question. Does he have one, Stacy, or? Does he?
I don't know. We'll just give her time. She's here and it's already 1:15.
That's 9:03.
How's 9:03?
I'm sorry, were you talking to me, Judge?
Yeah, don't worry. We'll reset you to 9:03. How's that?
9:03 is fine, Judge.
Okay, got it.
Okay. All right.
Oh, there's one more. This is on Clayton West, so, we need the date that he's going to be with.
Oh, right. On Mr. West, do you know when he's going to be released?
I don't think it's gonna be before his case is dismissed. He's set back on your docket on September 9th. He's probably gonna still be in that location in Dallas until then.
Okay, I guess, do you know where that location is? Do you have the phone number?
We have the location, we have the phone number, but because it's medical, they won't give us any information. And-
Will they
Well,
tell you whether he's
I'm telling you,
even
he's
there?
still there. He's still there.
I'm sorry.
Yeah, but my only fear is that he gets released. He's in complete non-compliance with the device at this moment. So if he takes off and he doesn't have the device like he should be, I'm issuing a warrant, okay? It's just been
Okay,
too
yeah.
much.
I think this
So
is kind of what we
please.
discussed when you weren't here last week. He's on 24-hour supervision right now where he is. So I
Okay.
think the state and I agreed that it's kind of counterproductive for him to have a GPS and be monitored.
Stacy, I agree with you, but
Okay.
all I want to know is the day that he's going to get released. That's all I want to know, unless it gets dismissed before that. Do you guys know who we're talking about? West? So West is in a treatment facility now.
Yes, Judge.
But I gave him a device so that we know where he was at,
Yes, yes,
but
yes.
it's,
That's the one that we called, right? That we were on the facility? Yes, Judge, I remember.
Oh, yeah.
what offer do you have now? Do you have a dismissal offer?
Can I get the call?
It's 261-2376.
Yeah, when I called the facility, judge, I would not answer. They said that they.
Yeah, it's a HIPAA. They're not gonna, yeah. We're gonna have to go through Stacy.
I mean, he's complied with everything as part of his mental health PTI.
Yes, Judge.
The only condition was that he needed to get treated,
The court is okay.
and which he's done.
His felony court did dismiss the case for mental health treatment. If the court would be okay with that as well, we would do that.
So you want to dismiss it now?
Yes, Judge. 'Cause
Yeah, well, that's up to you. If you want to dismiss it, then I mean,
The biggest thing, Judge, was to make sure that he got into treatment. It looks like he has been in treatment.
yeah, he's been in for a while, right? Stace? I know that he's been in a while
Yes.
because we've gotten drug tests from him and they've been,
He's been in treatment
Negative.
for 6 weeks.
yeah. All right, they're going to dismiss it now, Stace.
Thank you.
Okay, we're done.
Thank you.
So just kill the conditions. Okay,
Judge,
Yeah.
what are we saying for bond? Or
15,002. Yeah. Hey, can I give you one more cause number,
yes,
please?
Judge.
We need to do a cite and release, if you don't mind reading probable cause. 2634358 on a Johnson.
Mr. Johnson, Judge. Miss Johnson, sorry, Miss Johnson.
Oh, is it? Yeah, Miss Johnson, right.
Officers conducted a traffic stop for issue dim highlighted meeting. The violator turned onto public road in Harris County, Texas. Defendant who couldn't provide any form of financial responsibility. Officers were able to show that her driver's license was not eligible due to the following suspensions, which included DWIs, multiple violations going back to 2017, driving while license invalid. I think we should see that. and the financial responsibility.
Got it. Okay, I'll find PC then.